I've got a lot of concerns, but one of them refers to Reddit. At the time that the Department of Justice, at your behest or your involvement, gave Paul Gambetta immunity, did you do so knowing about all of the posts he had on Reddit and capturing all of those posts and correspondence where he was asking how to wipe or completely erase on behalf of a VVIP, so to speak?
I'm not sure sitting here. My recollection is, and I'll check this and fix it if I'm wrong, that we had some awareness of the Reddit posts. I don't know whether our folks had read them all or not. We had a pretty good understanding of what we thought he had done, but that's my best recollection.
Okay. In the last week, en masse, he's been deleting them from Reddit posts. Is that consistent with preserving evidence? And I say that because there's still an ongoing interest by Congress, and only in spite of Reddit's own senior, what they call flak team, trying to hide it, only because a few people caught it, do we even know about it, and is this and other committees interested in getting the backups that may exist on these deletions? I guess my question to you is he destroying evidence relevant to congressional inquiries? And I'll answer it for you, yes, he is. And what are you going to do about it?
That's not something I can comment on.
Well, let me go into something that concerns this body in a very specific way. As a former chairman issuing subpoenas, I issued a subpoena, and additionally, I issued preserved letters. In addition to that, now Chairman Chaffetz issued what were effectively preserved letters. Some of them were directly to Hillary Rodham Clinton while she was still Secretary. Others, the subpoena in 2013 was to Secretary Kerry. These individuals destroyed documents pursuant or took it out of federal custody pursuant to our subpoena and our discovery. As a result, they committed crimes. My question to you is, when I was a chairman and I wanted to grant immunity to somebody, I had to go notice the Department of Justice, and you were consulted. Isn't that correct?
In a particular matter?
In any matter.
I don't know whether the FBI is consulted in that circumstance.
Okay. For the record, yes, the Department of Justice does not grant immunity without checking with federal law enforcement to see whether it will impact any ongoing investigation. That's the reason we have a requirement to give notice. When the reverse was occurring, you were handing out like candy, according to some, immunity. Did you, or to your knowledge, Department of Justice, confer with Chairman Goodlatte, Chairman Chaffetz, Chairman Smith, or any of the other chairmen who had ongoing subpoenas and investigations?
Not to my knowledge.
So isn't there a double standard that when you granted immunity to these 5 individuals, you took them out of the reach of prosecution for crimes committed related to destruction of documents or withholding or other crimes pursuant to congressional subpoenas?
I don't think anybody was given transactional immunity.
Oh, really? Now, we have not allowed to make your immunities public, but I'm going to take the privilege of making one part of it public. I read them. You gave immunity from destruction to both of those attorneys, not just turning them over, the documents over, specifically destruction. You did the same thing with these other 2 individuals, Brian and Paul Gambetta. You gave them immunity from destruction.
Yeah, I don't think, well, again, I could always be wrong, but I don't have them in front of me either.
Well, because you don't let us take them out of the SCIF, it's a little hard for us too. But the fact is, when you read them—
my answer? I'm pretty sure that what was granted was use immunity. In the case of those 2 people, coextensive with 18 U.S.C. 6001, which means no statement you make can be used against you directly or indirectly. Transactional immunity is sometimes given also by prosecutors, says you will not be prosecuted in any event for this set of facts. I don't think there was any transactional immunity.
Well, when I read for both of the attorneys that immunity was granted, it's in both cases said destruction, in addition to the turning over. Why was that? Why would you believe that was necessary, or do you believe that would be necessary? You wanted the document, you wanted the physical evidence. Why did you have to give them immunity from destruction of materials? And because my time is expiring, when you look into it and hopefully get back to this committee, I'd like to know, does that immunity apply only to destruction on the computers delivered so that other destructions by Cheryl Mills could still be prosecuted?
Yeah, again, my recollection is no transactional immunity was given. A protection of statements was given to the Combetta guy and Mr. Pagliano.
Thank you, Mr. Chairman.
Director Comey, during questioning earlier, there was a dispute that arose over the contents of one or more of the immunity letters that were issued, particularly with regard to the issue of whether or not it contained immunity for destroying documents, emails. The individual who was questioning you about that was former Chairman Issa of the Oversight and Government Reform Committee, and I want him to be able to clarify, because we have contacted the Department of Justice and asked them to read the immunity letters to us. So the gentleman is recognized briefly.
Thank you, Mr. Chairman. I'll try to be very brief. Under the immunity agreement with one or more individuals, we'll use Cheryl Mills as clearly one of the individuals. She negotiated a very, very good deal from what we can discover. She did not just receive immunity related to the production of the drive, the computer, and the contents, but in fact received immunity under 793, 18 U.S.C. 793 E and F, 1924 U.S.C. 1920, 18 U.S.C. 1924, and the so-called David Petraeus portion, 18 U.S.C. 2071. And I'll focus on 2071. Her immunity is against any and all taking, destruction, or even obstruction, the way we read it, of documents classified or unclassified. Now, the only question I have for you is, and I know you're going to put this to justice, and we may have to ask them separately, for the purposes of what you needed as an investigator, because you were the person that wanted access to the computer, is that deal make any sense to, in return for things which she could have objected to as an attorney and held back, but which had no known proffer of leading to some criminal indictment of somebody else, she received complete immunity, as we read it, from obstruction or destruction of documents classified and unclassified, and that's based on a re-review of the immunity agreement.
Yeah, I think this is you're right. This is a question best addressed to Justice, but I think you're misunderstanding it. As I understand it, this was a promise in writing from the Department of Justice. If you give us the laptops, we will not use anything on the laptops directly against you in a prosecution for that list of offenses. It's not immunity for those offenses if there's some other evidence. Now, that said, I'm not exactly sure why her lawyer asked for it, because by that point in the investigation, we didn't have a case on her to begin with.
Well, I understand that, but based on the Reddit discovery and others, they asked me to do it, and you said so yourself, it was probably Cheryl Mills, they. You have an immune witness who has to tell you who they were. If they were told me to delete, and that's Cheryl Mills, then in fact you have evidence from an immune witness of a crime perpetrated by Cheryl Mills, the ordering of the destruction of any document classified or unclassified, which clearly she seems to have done.
But she wouldn't be protected from that. If we developed evidence that she had obstructed justice in some fashion, all she's protected from is we can't use as evidence something that's on the laptop she gave us.
So
We
with
can
the
still prosecute her.
Right. So the information put into the record today, which included these Reddit discoveries, show that there is a they who asked to have the destruction of information under 18 U.S.C. 2071. If she doesn't have immunity for that order, she could, and by definition should be charged, because ordering somebody else to destroy something as an attorney well after there were subpoenas in place that were very specific, that's clearly a willful act, isn't it?
Mr. Chairman, would you yield?
Of course.
Your line of questioning, first let me show my cards. I believe that Cheryl Mills has an impeccable character, as my line of questioning suggested that Director Comey and his staff have impeccable character. But my good friend, there's immunity given. I don't think this applies to Ms. Mills, and I looked at the sections that you're speaking of. If you take local criminal and state actions given to the worst of characters for a variety of reasons, that was not the reason given to Ms. Mills I am assured that it is a lawyer that was trying to be the most effective counsel to Ms. Mills as
Well,
possible.
reclaiming my time, the gentlelady's point may be true. I'm only speaking to the director based on things were done that should not have been done. We now have evidence in front of this committee, in the record, of people destroying records of activities as late as a few days ago. So the fact that there still should be an open question, first of all, is could she be prosecuted? And if, in fact, they have told me to destroy this, under the exact same statute that included David Petraeus's, who was no longer on active duty, 18 U.S.C. 2071, there's at least a case to be made. Now, the problem we have is the lawyer negotiated a set of terms which hopefully doesn't mean that she gets a free pass, even if she willfully ordered the destruction of documents, which it does appear she did. And look, my job is not to be judge, jury, or hangman. My job is to look at what's been presented to us, ask the highest law enforcement officer in the land to, in fact, look into it, because it does appear as though it is there.
A brief yield, my good friend.
Of course.
Certainly, we have a oversight responsibility of the director. I think he's been very forthright. But none of the actions of destruction can be attributed. I don't think we have anything in evidence to suggest that Ms. Mills contributed to the dictating or directing.
Well, the gentlelady may not have been.
Destruction.
The gentlelady may not have been here.
So we can't speculate here.
The gentlelady may not have been here at the time, but the director himself, when asked who would they would have been in that order to destroy, at least said it probably was or likely could have been Cheryl Mills. We're not saying it is. What we're saying is you have an immune witness.
The gentleman will suspend.
Of course.
The purpose of this was to set the record straight as to what the content of the document was. That has been accomplished, and the debate will continue on, but it will continue on outside of this hearing room.
And I would only ask,
speculate.
And I would only ask that the director be able to review those documents at Justice and follow up with the committee. Would be very helpful to all of us. I thank the chairman.